The Federal Trade Commission issued a ban on so-called worker non-compete clauses set to go into effect in the early fall, rallying praise from labor organizers and lawsuits from business groups.
Do you know the bogus non-compete agreements have affected at least 50 million Americans? Corporate America just lost a future fortune from its plans. Non-compete contracts will be banned with immediate effect. Will we finally get a job where we can work without being enslaved by corporations? Some businesses include non-compete terms in employment contracts, while others choose to develop separate non-compete agreements. Businesses that use non-compete agreements often require new employees to sign them during onboarding. You can, however, ask existing employees to sign them, either as a standalone contract or by altering their employment contract. However, to be enforceable in the United States, your non-compete agreement must follow the laws of the state in which your business is located. Some states, such as California, prohibit their use outright, while others limit when and how they can be used. Non-compete agreements, for example, cannot last more than a year in Utah. While they can be effective tools for securing company-sensitive information and attracting long-term employees, they can also increase your legal responsibility, be extensive to enforce and discourage top prospects. Why are these contracts bad for you? Most contracts between employer and employee are usually for mutual shared benefits, but most corporates find ways to make sure they get a profit at your expense. Non-compete agreements exist at a level of every sector: security guards, factory workers, foster parents, fast restaurant employees, and interns. Millions of poor and working class people are starving to survive and provide for their families, but they are unable to pursue better chances due to fraudulent non-compete agreements. Non-compete agreements are used in various settings, including salespeople, doctors, engineers, mortgage loan officers, and personal trainers. The fact that some of these persons earn more than others does not alter essential legal truth. The vast majority of non-compete agreements are not utilized to prevent unfair competition. They are employed to limit regular competition. What do these non-competes aim to achieve? The primary goal of non-compete agreements is to prohibit recently terminated employees from using sensitive business information to obtain a competitive advantage over their previous employer. However, these clauses also create some distance between an employee's experience at your firm and their new role, lowering the danger that the person will use the information they gained while working with you. This strategy helps to protect your company's sensitive information and intellectual property, such as client lists, business procedure, and product specifications. These agreements restrict employees from leaving your company. You may lessen employee turnover by encouraging them to stay for a long term. As a result, you secure your investment in employee onboarding, training, and other professional development while ensuring that no rivals benefits from it. Non-compete agreements can also help you maintain your competitive advantage by protecting your company's information, personal investments, and critical customer connections. This allows you to protect your firm's distinctive characteristics that set it apart from the competition, preserving your market share and assuring your company's long-term viability. Let us put this in a very simple term for you to understand. If someone can establish a firm, use Google to learn about it, get clients, and easily compete with you. It suggests you don't have any secret sauce, proprietary processes, protectable customer relationships, or extraordinary training. We're sorry to shatter their bubbles, but their real estate investment company, SEO firm, or private security guard company isn't a great thing since sliced bread. You do the same thing that hundreds, if not thousands, of other businesses do. America's non-compete dilemma was caused by management-side corporate lawyers attempting to create more work for themselves and increase money. Non-compete enforcement is a lucrative business for many major law firms. In the 1990s, these corporate law firms began lobbying for the extensive use of non-compete agreements. Non-compete agreements were intended to be the exception, not the rule. These business lawyers popularized the use of non-compete clauses, which allowed them to lay the groundwork for future non-compete enforcement cases and significant revenue streams. Of course, they will argue that what they're doing is in their client's best interest. It is not. However, many firms have been misled into believing the non-compete agreement as essential for risk management and company protection. It's become business as usual. But it's not just lawyers. Modern companies need a way of safeguarding their business, so their most experienced employees are bound to the company's future with these companies. But for the average employee, like most of us, there's a piece of good news. The Federal Trade Commission adopted a final rule in April to encourage competition by prohibiting non-competes nationally, protecting workers' fundamental freedom to change jobs, promoting innovation, and fostering new business creation. Non-compete clauses keep wages low, suppress new ideas, and rob the American economy for dynamism, including from the more than 8,500 new startups that would be created a year once non-compete are banned, said Lina M. Khan, chair of the Federal Trade Commission. She also emphasized that the FTC's final rule to ban the non-competes is a significant step towards ensuring that Americans have the freedom to pursue a new job, start a new business, or bring new idea to market, thereby empowering workers and fostering a sense of hope for a more dynamic job market. Now, according to the FTC, the final rule prohibiting non-competes will increase new business formation by 2.7% per year, resulting in the creation for more than 8,500 new enterprises per year. The final rule is predicted to increase workers' wages by an additional $524 per year, while also lowering healthcare expenses by up to $194 billion over the next decade. Non-compete agreements are not just a few isolated cases. They are a common and frequently exploitative practice that prohibits employees from choosing a new job or establishing a new business. These agreements frequently force employees to either stay in their job they want to leave or face other significant harms and costs, such as being forced to switch to a lower paying field, relocate, leave the workforce entirely, or defend against costly litigation. An estimated 30 million workers, or approximately 1 in every 5 Americans, are subject to non-compete agreements. Talk about corporate slavery. Existing non-compete agreements for the great majority of workers will no longer be enforceable after the FTC's new regulation goes into effect. Existing non-competes for senior executives, who account for less than 0.75% of employees, can stay in effect under the FTC's final regulation. But employers are prohibited from entering into or seeking to enforce any new non-competes, even if they involve senior executive. Employers will be compelled to notify employees other than senior executives who are bound by an existing non-compete agreement that no non-competes will be enforced against them. In January 2023, the FTC announced a proposed rule that was open to public comments for 90 days. The FTC received over 26,000 comments on the proposed regulation, with over 25,000 in favor of the FTC's proposed ban on non-competes. The comments guided the FTC's final rulemaking process, with the agency carefully analyzing each remark and making changes to the proposed rules in response to the public criticism. In the final rule, the Commission decided that entering into non-compete agreements with employees and enforcing certain non-competes is an unfair manner of competition and thus a violation of Section 5 of the FTC Act. Non-competes negatively impact labor market competitiveness by preventing efficient matching between workers and employers. The Commission also discovered that they negatively impact competitive circumstances in product and services industries, impeding the establishment of new businesses and innovations. There is additional evidence that non-competes result in increased market concentration and higher consumer pricing. Employers have long used trade secret laws and non-disclosure agreements, or NDAs, to protect proprietary and other sensitive information. According to researchers, more than 95% of workers and non-compete agreements already have an NDA. Employers could rather than employ non-compete clauses to lock in workers. Companies that want to keep them can compete on the merits of their labor services by enhancing wages and working conditions. But why would we expect these people to use their minds to make the employer not feel like a tool? You may think we're in the green, but these corporates just wouldn't give up without a fight. There is news that a federal judge preliminarily delayed the September 4 effective date of the ban of non-compete agreements for a handful of employers. Unless the judge rules otherwise before the date, the ban of non-compete agreements will take effect for the majority of corporations in the United States. However, they will find out later this summer whether it is still true. While this order is preliminary, the court intends to rule on the ultimate merits of this action on or before August 30, 2024, said Judge Ada Brown of the U.S. District Court for the Northern District of Texas. According to Jesse Coleman, a lawyer at the Houston legal firm Seyfarth Shaw, which represents SHRM, a human resource management association, there will most certainly be a concentrated effort between now and the end of August to persuade the judge to block the nationwide ban. Will the average employee finally get justice, or will our employers get the final laugh? If you found this video interesting, drop a like and be sure to check out other videos. Subscribe and let us know your thoughts, and we'll consider them for future videos.